Yato dharmas tato jayah. Where there is dharma, there shall be victory. Yah kriyavan sa panditah. Learned is the ones whose knowledge is animated by action. Respected dignitaries on and off the dais, esteemed scholars, honored guests, and dear colleagues. These two guiding principles, one enshrined in the motto of the Honorable Supreme Court of India and the other in the motto of Savitribai Phule Pune University, encapsulates the very essence of today's course of deliberations. For dharma without action remains unrealized, and knowledge without application remains incomplete. Victory is achieved only when justice perpetuates through the passage of time and wisdom transforms into deeds. Today, I, Sukhada Khedkar Tambe, along with my co-host Abir Tiwari, cordially welcome you to the two-day national seminar on 75 years of the Constitution of India, realizing the promise of justice. As we celebrate 75 years of the Constitution of India, we are reminded that our Constitution itself is a living example of this synergy, founded on the timeless principles of justice, equality, liberty, and fraternity, and sustained by the ceaseless efforts of institutions, citizens, and leaders who have given it life over 3/4 of a century.
Today, on the occasion of the inaugural ceremony of the National Seminar, we stand at this historic juncture to pay tribute to the visionary leadership of the distinguished members of the Constituent Assembly. Their collective wisdom gifted India not only with a legal framework, but with a compass guiding the constitutional values.
On behalf of Department of Law, Savitribai Phule Pune University, I extend our deepest gratitude to all the esteemed dignitaries for gracing this occasion. We also warmly welcome all the scholars, academicians, and participants who join us today to enrich this dialogue. May I now request our Chief Guest, Sir, Guest of Honor, Sir, and other dignitaries on stage to kindly proceed for the ceremonial lighting of the lamp. The lamp signifies the luminous guidance of the Constitution of India, enlightening society, dispelling the shadows of inequality and injustice, and inspiring us forward to the path of truth. Thank you all for gracing the lamp lighting ceremony.
At this moment, I request everyone present in the auditorium to kindly rise in respect for the national anthem, followed by the Maharashtra Geet and the Vidyapeeth Geet, hymns that celebrate the pride, culture, and indomitable spirit of the pursuit of wisdom.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
छातीवरी कोरली अभिमानाची लेणी
ओलादी मनगटे खेळती खेळ जीव घेणी
दारिद्र्याच्या उन्हात शिजला विठ्ठलाच्या घामाने भिजला देश गौरवासाठी झिजला दिल्लीचे ही रक्त घाली तो महाराष्ट्र माझा जय महाराष्ट्र माझा गरजा महाराष्ट्र माझा जय जय महाराष्ट्र माझा
पुण्यमयी देया महाअक्षर वरदान पुण्यमयी देया महाअक्षर वरदान ज्ञान बनो कर्मशील कर्म ज्ञानवान ज्ञान बनो कर्मशील कर्म ज्ञानवान पुण्यमयी देया महाअक्षर वरदान जाति भेद धर्म भेद वंश भेद दूर लाख लाख कंठातून हाच एक सूर जाति भेद धर्म भेद वंश भेद दूर लाख लाख कंठातून हाच एक सूर करुणेच्या चरणाशी नत हो विज्ञान ज्ञान बनो कर्मशील कर्म ज्ञानवान पुण्यमयी देहा महाअक्षर वरदान माणूस की धर्माचा अर्थ जाणतो श्रमनिष्ठा हे पवित्र तीर्थ मानतो माणूस की धर्माचा अर्थ जाणतो श्रमनिष्ठा हे पवित्र तीर्थ मानतो हृदयातून समतेचा निर्भय अभिमान ज्ञान बनो कर्मशील कर्म ज्ञानवान पुण्यमयी देया महाअक्षर वरदान सेवेतच मुक्ती ही मंगल दीक्षा न्यायास्तव जागृती ही सत्व परीक्षा सेवेतच मुक्ती ही मंगल दीक्षा न्यायास्तव जागृती ही सत्व परीक्षा हे विश्वचिखर अमुचे मंत्र हा महान ज्ञान बनो कर्मशील कर्म ज्ञानवान पुण्यमयी देया महाअक्षर वरदान पुण्यमयी देया महाअक्षर वरदान ज्ञान बनो कर्म
Thank you, everyone. Please be seated.
May I now invite Shri Ravindra Shingnapurkar Sir, Chancellor's nominee and Member Management Council, Savitribai Phule Pune University, to kindly deliver the welcome address, setting the tone for today's deliberation.
नमस्कार. सावित्रीबाई फुले पुणे विद्यापीठ, संविधान अमृत महोत्सव समारोह समिती आणि विधी विभाग यांच्या वतीनं आयोजित करण्यात आलेल्या 75 इयर्स ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया रिअलायझिंग दी प्रॉमिस ऑफ जस्टिस या 2 दिवसीय चर्चासत्रामध्ये उद्घाटन सत्रासाठी आपल्यामध्ये उपस्थित असणारे भारताचे माजी सरन्यायाधीश माननीय डॉक्टर DY चंद्रचूड सर, सावित्रीबाई फुले पुणे विद्यापीठाचे कुलगुरू डॉक्टर सुरेश गोसावी सर, विशाखापट्टणमच्या DSNLU या विद्यापीठाचे संस्थापक कुलपती डॉक्टर A लक्ष्मीनाथ सर, प्रभारी कुलसचिव डॉक्टर ज्योती भाकरे मॅडम, अधिष्ठाता डॉक्टर विजय खरे सर, विधी विभागाचे प्रमुख डॉक्टर नरेश वाघमारे सर, संयोजन समितीचे सदस्य असणारे उच्च न्यायालयातील वकील डॉक्टर उजय वारुंजीकर सर, डॉक्टर सानिया नागराळे, तसेच संयोजन समितीचे सदस्य ॲडव्होकेट ईशानी जोशी, राहुल पाखरे, कृष्णा भंडलकर, सभागृहामध्ये उपस्थित असणारे व्यवस्थापन परिषदेच्या सदस्य वागेश्री मंठाळकर, तसेच सभागृहातील सर्व मान्यवर, विविध महाविद्यालयांचे प्राचार्य, पुण्यामध्ये आणि मुंबईमध्ये प्रतिष्ठितपणे काम करत असणारे विधिज्ञ, शिक्षक, विद्यापीठामधील विविध विभाग प्रमुख, इथले शिक्षक, शिक्षकेतर कर्मचारी आणि विद्यार्थी बंधू भगिनींनो, या 2 दिवसीय चर्चासत्रामध्ये आपल्या सर्वांचं मनपूर्वक स्वागत. विद्यापीठ, आत्ताच आपण विद्यापीठ गीत सगळ्यांनी म्हटलं. विद्यापीठाचं गीताची सुरुवातच आहे की ज्ञान बनो कर्मशील, कर्म ज्ञानवान. आणि ज्ञान फक्त लेक्चर्समधनं होतं असं नाही, तर ते अशा खूप साऱ्या परिसंवादांमधनं, चर्चासत्रांमधनंही होत राहतं. तसंच समाजातल्या अन्य विविध घटनांमधनंही आणि त्यानिमित्तानं होणाऱ्या चर्चा मंथनांमधनंही होत राहतं. आणि हा विद्यापीठाचं अगदी पहिल्यापासूनच ब्रीदवाक्य असल्यामुळं विविध परिसंवाद आणि अनेक गोष्टींचं आयोजन हे सातत्याने केलं जातं. हे वर्ष 5 वेगवेगळ्या विषयांसाठी विद्यापीठाच्या माध्यमातून आपल्यासमोर येणार आहे. त्यातला एक जे आपल्याला दिसते, संविधानाचा अमृत महोत्सव, या निमित्तानं जी समारोह समिती आहे त्यांनी काही गोष्टी या निमित्तानं विद्यार्थ्यांपर्यंत आणि समाजापर्यंत पोहोचवण्याचं ठरवलं. त्याचा एक भाग म्हणून हे चर्चासत्र आहे, ज्याच्यामध्ये संविधानाच्या रिअलायझिंग दी जस्टिस, न्यायाच्या विषयामधलं आपलं ज्ञान किंवा त्याच्या विषयाची आपली समजून घेणं, न्याय त्या अर्थाने संविधानाचा, या प्रकारचं जे चर्चासत्र आहे हे थोडंसं अकॅडमिक आहे आणि याचाही आवश्यकता नेहमी असते. बऱ्याच वेळा कोर्टांमधनं लॉविषयी खूप चर्चा होते, पण कॉन्स्टिट्यूशनची या अर्थाने चर्चा व्हावी म्हणून या चर्चासत्राचं आयोजन केलं गेलं आहे. याबरोबरीनंच विद्यार्थ्यांपर्यंत हा विषय पोचावा यासाठी 75 महाविद्यालयांमध्ये विविध ठिकाणी, म्हणजे पुणे विद्यापीठाची 4 भाग आहेत, पुणे शहर, पुणे जिल्हा, नगर आणि नाशिक जिल्हा, इथल्या सगळ्या मिळून 75 महाविद्यालयांमध्ये या विषयावरची व्याख्यानं होणार आहेत. या विषयावर असणाऱ्या शोभायात्रा त्या विद्यार्थ्यांमधनं त्या गावांमध्ये त्या ठिकाणी होतील. पथनाट्यांच्या माध्यमातून संविधानविषय पोचवला जाईल. याबरोबरीनंच निबंध स्पर्धा आणि वक्तृत्व स्पर्धा यांचंही आयोजन राष्ट्रीय सेवा योजना आणि विद्यार्थी कल्याण मंडळाच्या माध्यमातून हे सगळं आयोजित केलं जाणार आहे. जसं संविधान 75 अमृत महोत्सवाचा विषय आहे, तसंच अन्यही 4 गोष्टी यावर्षी महत्त्वपूर्ण आहेत. त्याच्यामध्ये वंदे मातरम या राष्ट्रगीताचीही 150 वर्ष यावर्षी आहेत. अहिल्याबाई होळकर यांच्याही त्रिजन्मशताब्दीचं हे वर्ष आहे. भगवान बिरसा मुंडांच्या 150व्या जन्माचं हे वर्ष आहे. आणि एकात्म मानवदर्शन या विषयाचीही 60 वर्ष या पूर्ण होत आहेत. अशा सर्व विषयांमध्ये विद्यापीठ याच प्रकारच्या विविध कार्यक्रमांचं आयोजन करणार आहे. या सगळ्या कार्यक्रमांची एका अर्थाने सुरुवात ही या परिसंवादाच्या माध्यमातून होती आहे आणि सगळे मान्यवर आणि आपण सगळे यासाठी इथं उपस्थित आहात याचा विशेष आनंद आम्हाला सगळ्यांना आहे. आज या 2 दिवसीय चर्चासत्रामध्ये विविध विषयांवरची चर्चा, 5 वेगवेगळ्या विषयांची मांडणी होईल. उद्घाटनाच्या सत्रामध्ये व्हॅलिडिक्टरी फंक्शन्समध्ये या विषयातली ही चर्चा होईल. 145 विविध प्रकारचे पेपर्स या निमित्तानं यामध्ये सहभागी झालेत. देशाच्या सर्व कोपऱ्यांमधून म्हणजे आसाम ते गुजरात आणि काश्मीर, जम्मू ते केरळ अशा सर्व ठिकाणाहून पेपर्स या परिसंवादात आलेले आहेत. त्याचीही 2 सेशन्स आज आणि उद्या याची पेपर सादरीकरण हे होणार आहे. या सगळ्या परिसंवादामध्ये आपल्या सगळ्यांचं स्वागत आणि शुभेच्छा. धन्यवाद.
Thank you, sir, for your inspiring words. Further, I invite the head of the Department of Law, Savitribai Phule, Pune University, Professor Dr. Naresh Wagmare, sir, to introduce the theme of this national seminar. Sir, may I kindly request you to address the gathering?
Honorable dignitaries on the dais, former Chief Justice of India, Justice Dr. Dhananjay Chandrachud, sir, Honorable Vice Chancellor of our university, Professor Dr. Suresh Gosavi, sir, Professor A. Lakshminath, sir, Advocate Dr. Uday Varanjikar, sir, Sri Ravindra Shingnapukar, sir, Professor Jyoti Bagre, ma'am, Professor Vijay Khare, sir, Honorable dignitaries of the dais, Justice Srikant Kulkarni, sir, the head of the departments of various subjects, Dr. Adhav, sir, Principal Honab, ma'am, Management Council member Mandhalkar, ma'am, my professor, Professor Hirani, sir, Dr. C.M. Rao, sir, Dr. Anand Deshmukh, Dr. Oak, sir, and Dr. Payal Thavre, ma'am. So all the dignitaries, I welcome on the behalf of the Department of Law. As we celebrate 75 years of the Constitution of India with the Department of Law and the Savitribai Phule Pune University have organized this 2 days seminar on the theme of justice. We know very well that the Constitution of India, it is a legal document, it is a visionary document, it is a evolutionary document as such, which has changed the lives of all of us. The preamble of the Constitution, it states that we the people of India having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic and to secure to all its citizens justice. And this is the theme of our seminar, justice, social, economic and political. There are many constitutional values like justice, equality, liberty, fraternity. Among them all, justice comes the first. And when we talk about the justice, there are the various dimensions of justice like social, economic and political. Herein also, we find here the social justice comes the first. And therefore, to discuss the concept of justice and the various dimensions of the justice, we have invited various resource persons, Professor A. Lakshminath, sir, Professor Dilip Uke, sir. There are also the High Court judges, Justice R.C. Chauhan, sir, Justice Ambadas Joshi, sir, and also the practicing lawyers like Advocate Dr. Uday Varanjikar, sir, Advocate Dr. Rajendra Anbule, sir. So they will be discussing on various aspects from various perspectives like Indian ancient jurisprudence, social justice, administration of criminal justice, judicial process. At the same time, I must say that as our Sri Shingnapur sir has mentioned, about we have received more than 150 abstracts of research papers across various states in India. And the very important thing which I would like to mention here, that around 100 papers will be presented in various paper presentation sessions on various themes of the Constitution. At the same time, there are these seminar presentation papers will be shared, examined by the experts like the professors and the principals of various colleges. So I must thank all the participants who have joined with us for discussing the theme of the seminar at this occasion. So thank you one and all. Thank you.
Thank you, sir. We now come to one of the most important moments in this inaugural sessions. It is our privilege to formally introduce and felicitate our chief guest for today's national seminar, Honorable former Chief Justice of India, Justice Dr. D.Y. Chandrachud, sir. May I invite to the podium the Honorable Officiating Registrar of Savitribai Phule Pune University, Professor Dr. Jyoti Bhakre ma'am, to introduce and extend a warm welcome to our distinguished chief guest.
Thank you. A very good morning to one and all. As mentioned in Vidyapith Geet, we assemble here for Nyayastava Jagruti. It's really my honor to introduce today's chief guest, who is really Nyaya Devata sitting with us. Honorable Dr. Justice Dhananjay Yashwant Chandrachud. Honorable Dr. Justice D.Y. Chandrachud, born on 11th November 1959, stands as one of the most eminent jurists in contemporary Indian legal history and served with distinction as the 50th Chief Justice of India between 2022 and 2024. The son of the former Honorable Chief Justice of India, Y.V. Chandrachud, he received an education from St. Stephen's College, University of Delhi for BA in Economics and Mathematics, Campus Law Center, University of Delhi for LLB, and then from Harvard Law School, where he secured degree of LLM, along with obtaining an INLAC scholarship and received Joseph Billy Prize for securing the highest marks in conflict of laws course. Then he completed his research in Harvard Law School for Doctor of Juridical Sciences. While working as an advocate in Mumbai, he appeared in cases involving the rights of bonded women laborers and religious and linguistic minorities and laborers who were denied employment after they were found HIV positive. While practicing as an advocate, he remained involved in legal academics as well by taking a position as a visiting professor of comparative constitutional law at University of Bombay between 1988 and 1997. He has also had an illustrious academic presence, serving as visiting professor and lecturer at Harvard Law School, Yale University, the University of Oklahoma, and several national law universities across India. Honorable Justice Chandrachud has delivered distinguished lectures at global fora, including the Standing International Forum of Commercial Courts and the National Judicial Academy, Bhopal, where he repeatedly underlined the role of technology in enhancing access to justice. In 1998, Dr. Chandrachud was designated as a senior advocate at just the age of 38. Such a meritorious designation is rarely given to advocates below the age of 40. Honorable Justice Chandrachud commenced his judicial career as a judge of the Bombay High Court in 2000 before assuming the office as Chief Justice of the Allahabad High Court in the year 2013. His elevation to the Supreme Court of India in the year 2016 was followed by his swearing in as the 50th Chief Justice of India on 9th November 2022. His tenure on the bench was characterized not only by his stewardship of constitutional benches of historic significance, but also by his commitment to modernizing and strengthening India's justice delivery system with particular emphasis on integration of technology. Also known as the rock star of the Indian judiciary, His judgments have touched upon matters of privacy, bodily autonomy, federalism, affirmative action, and even arbitration. This has certainly left the judiciary in a better place where he actually found it. Over the 8 years as the Supreme Court judge and 2 years as the Honorable Chief Justice of India, he delivered some of the India's most important judgments. You can differentiate the Chandrachud verdict from the others just by looking at it. The careful structuring, the neat laying out of conclusions, the high-minded rhetoric, and the use of foreign judgments. These features are so specific to his rulings that he was easily identifiable as the author of the Ayodhya Ram Janmabhoomi judgment, even when it did not specifically cite him as one of his. Honorable Justice Chandrachud has had an enormous impact on the constitutional jurisprudence of India, particularly in the areas of right to privacy, reservation, free speech, and so on. He has changed the way the Indian courts think about these issues. While other judges on the bench have also written the judgments in these cases, it is Chandrachud's opinion, much like Justice Krishna Iyer's pages that we study in our curriculum, that has been frequently highlighted as the opinion of the Supreme Court. A great example of this is the 9-judge bench decision in Justice K.S. Puttaswamy's case, which established the right to privacy as a fundamental right in India. The 2017 verdict, where His Lordship wrote the lead opinion, defined privacy in broad but clear terms, something that significantly impacted different areas of law and will continue to do so. In Navtej Singh Johar versus Union of India, His Lordship wrote a powerful concurring opinion that contributed to the decriminalization of consensual same-sex relations under Section 377 of IPC, emphasizing the dignity and equality. In Indian Young Lawyers Association versus State of Kerala, which we know as Shabrimala case, His Lordship's opinion underscored the constitutional mandate of gender justice and morality. In the Aadhaar case, notably again as K.S. Puttaswamy versus Union of India, His Lordship's dissent trenchantly criticized the passage of the Aadhaar Act as a money bill and cautioned against the systemic risk posed to privacy and dignity by biometric identification. The Article 370 judgment also shows how rhetoric can be deployed to cover up outcomes favoring the ruling dispensation, though slightly in a different manner. The feminist perspective is apparent in his judgment, like Lieutenant Colonel Niti Shah's case, where he recognized the concept of indirect discrimination and held that women should also be considered for receiving permanent commissions in army. Shaira Banu versus Union of India, also known as Triple Talaq case, striking down instant talaq, is another such example. Joseph Shine versus Union of India dealt with decriminalization of adultery. In this 5-judge bench, in a separate concurring opinion, Honorable Justice Chandrachud wrote that the law on adultery is but a codified rule of patriarchy, and it perpetrated the regressive idea of women's subordinate role in marriage. On September 29, 2021, in a progressive ruling on International Safe Abortion Day, the Supreme Court extended abortion rights under the MTP Act to the unmarried women as well. Honorable Justice Chandrachud asserted that laws should not discriminate based on marital status and must reflect contemporary societal values regarding women's autonomy. Honorable Justice Chandrachud has worked wonderfully in the matter of Common Cause versus Union of India, another landmark case which recognized the rights of terminally ill patients to die with dignity and discussed about living will and passive euthanasia. His Lordship's judicial philosophy is marked with bold dissents, and visionary concurrences which have frequently set the course of future jurisprudence. His judgments have consistently advanced gender equality, reinforced civil liberties, and safeguarded constitutional morality. One of the Honorable Justice Chandrachud's most lasting contributions, according to us, may be his efforts to modernize Indian judiciary. His commitment to e-courts projects, which expanded virtual hearings, live streaming, and digitized court records, marked a transformative shift. Under this initiative, several landmark projects were introduced, including the e-SCR project for digital access to Supreme Court reports, an online database of Supreme Court judgments, and a neutral citation system. Under his lordship's leadership, the judiciary embraced technological advancements such as AI-based transcription of hearings and translation services in regional language, making the courts more accessible to the public. In many ways, Honorable Justice Chandrachud also shattered the glass pane that traditionally separated judiciary from the public. His openness to the media made the office of Chief Justice of India more accessible than ever before and made the judiciary more approachable and less insular. Beyond adjudication, Honorable Justice Chandrachud has distinguished himself as a jurist deeply invested in legal scholarship, judicial reform, and public engagement. Honorable Justice Chandrachud is widely regarded as a progressive reformer for all the actions he did during his tenure as the judge of Supreme Court of India and, of course, as the Chief Justice of India as well. We are really honored, sir, to have you with us today as such a legal luminary, as the chief guest to guide us on account of 75 years of the Constitution of India when it is realizing the dream of justice. Once again, on behalf of Savitribai Phule, Pune University, I extend a warm welcome. Thank you.
Thank you, ma'am. Now, with great respect, I invite the Honorable Vice Chancellor, Savitribai Phule, Pune University, Professor Dr. Suresh Gosavi, sir, to kindly come forward and felicitate our esteemed chief guest, Honorable former Chief Justice of India, Justice Dr. D.Y. Chandrachud, sir. We now proceed to the next important part of our inaugural ceremony, the felicitation of our distinguished guest speakers. It is indeed our honor that this felicitation will be done at the hands of none other than our chief guest for the day, Honorable former Chief Justice of India, Justice Dr. D.Y. Chandrachud, sir. First, I invite Professor Dr. A. Lakshminath, sir, respected Professor Emeritus, Maharashtra National Law University, Chhatrapati Sambhaji Nagar, and former Chancellor of DS National Law University, Visakhapatnam. May I now invite Advocate Dr. Uday Varunjikar, sir, distinguished senior advocate of the Bombay High Court and an eminent voice in constitutional and public law, to kindly come forward and receive his felicitation.
May I now invite Advocate Dr. Rajendra Anbhule, sir, a distinguished member of the Bar and Supreme Court advocate on record, whose professional excellence and dedicated service to the cause of justice have earned him deep respect within the legal fraternity. Finally, I invite the chairpersons of our technical sessions on the stage for felicitation at the hands of our honorable chief guest, Dr. Asmita Vaidya ma'am, Dr. Payal Thaure ma'am, Dr. C.M. Rao sir, Dr. Vijay Oak sir, Dr. Rohini Honap ma'am, Dr. Atul More sir, Dr. Salim Sheikh sir, Dr. Ananya Bibwe ma'am, Dr. Pratap Sarunge sir, Dr. Kranti Deshmukh ma'am, Professor Anand Deshmukh sir, Professor M.H. Hirani sir, Justice Shrikant Kulkarni sir,
Thank you, Honorable Chief Guest, sir, and our esteemed guest speakers for accepting this gesture of regard and for your valued presence. May I now request the Chief Guest and our distinguished speakers to kindly take their seats as we proceed with the program. I now invite Honorable Vice Chancellor Savitribai Phule, Pune University, Professor Dr. Suresh Gosavi, sir, to address this seminar.
Namaskar, Suprabhat, good morning, and welcome to the beautiful campus of Savitribai Phule, Pune University for this two-day national seminar on 75 years of Constitution of India. realizing the promise of justice, which is being organized by Department of Law, Savitribai Phule Pune University. For the inaugural function, we have the chief guest, Dr. D.Y. Chandrachud, Honorable former Chief Justice of India. On behalf of Savitribai Phule Pune University, I welcome you, sir, on this beautiful campus, and I also thank you very much for accepting our invitation and be here for the celebration of this 75 years of Constitution. Again, we have the Honorable Professor Dr. A. Lakshminath, Professor Emeritus, NLU, Sambhajinagar. Thank you very much, sir. Then we have our organizing committee member. I'll now skip some of the name because in the interest of time, I have to go ahead. Organizing committee member, my colleagues and friends, it's indeed a pleasure to welcome you on behalf of Savitribai Phule Pune University. Just to make a mention here that Savitribai Phule Pune University is one of the state leading university in the state of Maharashtra. As far as jurisdiction is concerned, okay, we are Nashik, Nagar, and Pune jurisdiction. At the same time, we have 800 colleges and 400 research institutes affiliated with us. At one point of time, we have 7.5 lakh students doing their graduation and post-graduation along with their PhD program. Of course, Savitribai Phule Pune University has also completed 75 years. And for the good cause, we are here in this particular hall to discuss, okay, how important the Constitution is. And for that one, okay, the deliberation and discussion with the eminent people will be very important. So, as far as the ranking of the university is concerned, in the recent QS ranking, as a state university, we are number 1 in the state, number 3 in the entire state university in the country, and number 15 in the overall. But at the same time, in the national NIRF ranking, okay, we have a little drop down for some reason because the parameters for evaluations are different. And then, okay, from single digit, we have went to the double digit. Nevertheless, this is the first state university which has opened its offshore campus in Qatar, and the first batch will be graduating, wherein I think law from this year will be introducing law in Qatar. Okay, this is what we have been expanding ourselves. As a first step of implementation of national education policy, Savitribai Phule Pune University is always leading, and towards internationalization of higher education, we have started BSc blended course in association with Melbourne University. We are also running a master's program with Drexel University, and probably as the internationalization of higher education invites foreign university to Maharashtra, probably we'll be joining hands with the leading universities in state and also UK. Probably next year. We are also planning to open our campus in Dubai, Saudi Arabia, and Kazakhstan next year, okay? One more thing I like to mention here that, okay, like we have got a request from Erwada Jail, okay, how to give education to the prison. And the first step, Savitribai Phule Pune University will be giving education to the prison who are there, okay, and will be conducting our law course there. This is what we have been doing. I think in a nutshell, you name the equipment, especially in science and technology, we are leading. You name the equipment, it's present on campus. The Savitribai Phule Pune University is being considered as University of Potential Excellence by UGC. It is being considered as a Potential Excellence University by Department of Science and Technology. And we have been really leading in science and technology. We are really working towards the need to the society. And the first step of that, okay, we are always working with the upcoming area of research in science and technology, humanities. Of course, okay, law is one of the department which is leading. And I think when I have heard the conversation with the honorable guest here, okay, like everyone is sharing, when they are coming here, okay, they are sharing their experience with him. So I think I'm not an authority to talk about law because I started understanding law after becoming a vice chancellor because I have to look at that, okay. From that perspective, I think it will be a good idea not to speak, okay, the area which you are not comfortable. But on the other hand, as we are talking about this celebration of 75 years, okay, it's just not passage of a 75 years of Constitution, but enduring the journey of document that has been foundation of our Republic. This milestone invite us to reflect the transformative vision of justice, liberty, equality, and fraternity that Constitution enshrines and acknowledge the religions and with which it has guided our nation through challenges and changes. 75 years is not merely a mark of time. It is a testament to the living spirit of democracy that constitutes to inspire us, reminding us the Constitution is not a relic of the past, but promise to the future, a promise that must be realized in lives of every citizen. I think with this brief introduction, okay, on behalf of Savitribai Phule Pune University, I welcome all the delegates who have all the way traveled from, I think, Kanyakumari to Kashmir. This is what I have understood from the organizer. They have also mentioned that, okay, we have large number of abstract which we have received, and then out of that, few will be presenting there. But on the other hand, the discussion and deliberation with the young generation, with the senior eminent people who have been in this particular area of justice, okay, that will give them a boost to understand how important this particular area is in the area of 21st century, where people have been now transferring from book to digital. So digitization, and this is one of the challenges which we have to really face. To mention here that in Pune is a cultural city, it's an education hub, it's an auto hub, it's IT hub, and now it is gaining new identity as biodesign, bioengineering hub. So in Pune, Honorable Sir, there are 34 universities, and we are the leading university in the state of Maharashtra. At the same time, we are leading in Pune. With this brief introduction about the university, I welcome you all, and I hope that the discussion and deliberation in these 2 days will really help the new generation, young generation, to look at this particular area from positive side, so that, okay, they will be witnessing Vikasit Bharat 2047. Once again, I welcome you all. Namaskar, Jai Hind.
Thank you, sir. Distinguished guests and participants, we now approach the moment this assembly has most eagerly awaited. We count it a matter of profound privilege to now listen to the inaugural address of our chief guest, Honorable former Chief Justice of India, Justice Dr. D.Y. Chandrachud, sir. With greatest respect and anticipation, I now invite Honorable Justice Dr. Chandrachud, sir, to deliver the inaugural address. Sir, we await your words with keen attention and reverence.
The Vice Chancellor, Dr. Suresh Gosavi, the Pro-Vice Chancellor, the conveners, Dr. Shingnapurkar and Dr. Bhakre, the chief coordinators, Dr. Khare and Dr. Wagmare, Dr. Nagraye, members of the coordinating committee, my good and learned friend, Dr. Uday Varunjikar, Senior Advocate of the Bombay High Court, and young students attending this lecture. I'm privileged that Dr. Lakshminath is present this morning because he's an academician whom we have all come to respect by his long experience and dedication to the cause of imparting education to young people. So I'm grateful to you, Dr. Lakshminath, for attending my address this morning. I thank you all for inviting me on behalf of the Savitribai Phule University for this inaugural session. Pune is a city of multitudes. It bears the distinction of being called the Oxford of the East, with its rich academic tradition and intellectual vigor. My father studied exclusively in Maharashtra, Nutan Marathi Vidyalaya, Elphinstone College, and then ILS Law College, Pune. When he was always asked whether he learned the good English that he spoke and wrote at Oxford, he would always say, my Oxford was Nutan Marathi Vidyalaya. But a visitor to the beautiful campus of the Savitribai Phule Pune University may well be justified in calling Oxford the Savitribai Phule University of the West. Aside from being the cultural capital of Maharashtra, the university holds tremendous influence in shaping and dissemination of progressive values that shaped India's quest for a more equal society and the struggle for freedom. These values have found residence in our constitution and continue to govern our lives and contemporary discourse. Historically, Pune was in the vanguard of social reform. It was in some senses the epicenter of intellectual ferment which transformed 19th century Maharashtra. Maharashtra presents a continuing tradition of progressive thought over 7 centuries. It is a model of how intellectual ferment within a city, within a state, within a geographical area and its institutions can generate universal principles of fraternity, social equality, and democratic governance. As we contemplate the extraordinary journey of our Constitution, we must begin by tracing the rights which our Constitution embodies in the ideas of social reform which were espoused by political and social reformers from Maharashtra. These thinkers birthed, in a fundamental sense, our quest for an egalitarian society. The Constitution has to be interpreted as a living document, not as a parchment on paper, but as something which is living, vibrant, deliberative, rational, and emotional as well. That is how we find room to accommodate new dimensions to the black letter of constitutional rights. For a distinguished judge from the US, Justice Oliver Wendell Holmes, the life of the law was not logic but experience. In our times, this means that we must account for historical perspectives that have mirrored social reality. In interpreting the Constitution, we must not only account for the structure and the text of the document, but centuries of political thought and struggle against the colonial state and against the evils of caste discrimination, patriarchy, and other social evils. It is only when we understand the Constitution from the perspective of the history, both politically and socially, of the people within this great nation, that we will truly begin to understand that the Constitution is not a borrowed document, but a homegrown document. At the heart of the fundamental rights chapter lies the sanctity of the individual. We only understand ourselves and our world through the bonds we forge with one another and the communities to which we belong. Our preamble guarantees to secure to all citizens of India liberty, equality, fraternity, and justice. It places the individual at the forefront of the constitutional project. But we must begin with the reformist traditions and egalitarian ideals in Maharashtra. The Bhakti movement tradition of the 13th and 14th century arose in Maharashtra. It had a profound effect on the lives of ordinary people who were otherwise kept away from privilege and dignity on account of their social status. The Bhakti poets, devotees of the deity of Pandharpur, of the Warkari tradition, started temple movements to allow for the entry of those who were denied entry into temples, sending out the message that God or spirituality was not the sole prerogative of any segment. So when our judgment in the Sabrimala case is mentioned as opening up or an attempt to open up the Sabrimala temple to women in the menstruating age group on the ground that you cannot deny a woman the right of prayer on the ground of her menstrual status, in a fundamental sense, we were merely replicating the basic call for social reform and democratization of spirituality, which began with the Bhakti movement and which was embodied in the Constitution. Sant Jnaneshwar presented a commentary on the Gita, the Bhagavad Gita, which remains a one-of-a-kind articulation of democratizing spirituality. He asserted, Aughe Vishwats Maze Ghar, the whole universe is my home, reflecting the fundamental constitutional precept which was adopted centuries later, that dignity is universal, without the constraining features of religion or sex or caste or gender. So Sant Jnaneshwar sent out the message of universal citizenship and belonging. Sant Tukaram's famous Abhanga, what is pure and what is impure? Water remains water whether from the well or river. Milk retains its color regardless of the cow's hue. Criticized social hierarchy, which kept individuals away from the mainstream on the grounds of caste, and which now bears echoes in Article 15's prohibition of discrimination based on religion, race, caste, sex, or place of birth, or descent, or any of them. The great sants, Sant Namdev, Chokhamaya, Eknath, Ramdas, all represented a vision of progressivism, a collective rejection of the idea that individuals are to live and die on the basis of the social strata assigned by birth. They instead advocated that all individuals have the right to faith and dignity. In the 18th and 19th century, this tradition of political thought went beyond religious and spiritual movements. Several individuals were instrumental in founding the trajectory of our struggle for freedom and opposing social evils prevalent in society. To understand the Constitution, you must therefore understand two parallel streams of thought which were taking place. First, the struggle against colonial rule, against being ruled by a foreign power. But equally important was the struggle for social emancipation. Both coincided together and coalesced in the formulation of the Constitution. Rajarshi and Chhatrapati Shahu Maharaj of Kolhapur, recognizing the deep-rooted discrimination and exclusion prevalent in society, introduced affirmative action policies for students belonging to disadvantaged classes. He invested in women's education, supported intercaste marriages, and advocated for breaking social taboos. He was thus one of the early architects of social justice, whose ideals are reflected in our constitutional framework today. Mahatma Jyotirao Phule challenged orthodoxy through his work titled Gulamgiri. He championed education for the disenfranchised and advocated economic self-reliance and political representation to equality in its fullest sense. Savitribai is often regarded as the first female teacher. Despite facing severe social ostracism and opposition, including stones and dung being thrown at her while going to school, Savitribai persevered in her mission. Lokmanya Balagangadhar Tilak reminded us that Swarajya is our birthright, that there are rights which are inalienable to human existence. We overruled the emergency judgment in ADM Jabalpur, in our judgment in Puttaswamy, by saying that the right to life or personal liberty is not conferred by the Constitution. Therefore, the suspension of the right to life or personal liberty during an emergency does not affect the element of the right to life which lies outside the Constitution, which merely the Constitution has recognized. But Lokmanya Tilak spoke about this years before the Constitution was envisaged, when he said that this is my birthright. It is inalienable. So long as I exist as a human being, Swarajya is something which cannot be denied to me. For asserting those rights, he was led to Mandalay, and you have to only stand outside the central court in the Bombay High Court, where he said to the jury that there are higher powers that guide the destiny of men. And it may be the will of providence that the cause which I represent may benefit more by my suffering than by my remaining free. Powerful words for a person who knew that he was going to be transported. Gopal Ganesh Agarkar emphasized rationalist agenda. So the Constitution embodies both faith and rationalism. It speaks about the freedom of religion, but it speaks of the freedom of conscience as well. And therefore it emphasizes reason and rationality as much as it respects faith and religion on an egalitarian basis. Educated at the Deccan College, where he was introduced to ideas of Western Enlightenment thinkers, Agarkar believed that both caste hierarchies and gender subordination owed their persistence to ignorance and superstition. He believed in the power of legislation to initiate social reform, and his efforts were key to the passing of laws like the Child Marriage Restraint Act of 1929. Justice Mahadev Govind Ranade also advocated for these causes through his belief in gradual reform via legal and educational means. The pioneering feminist scholar Pandita Ramabai exposed the cruelties of child marriage and sati, influencing debates in both British Parliament and in Indian social circles. A few decades later, Maharishi Dhondukeshav Karve established India's first women's university in 1916 with the motto that an enlightened woman is a source of infinite strength. In protest against the treatment of widows in Hindu society, he broke all norms of propriety of that era by marrying a widow. He felt the pain of the downtrodden, and his activism shone with dignity. The ashrams he established gave many orphans, widows, the ill and the unwell the opportunity at a new life that they could lead with independence and autonomy. Noting that women's freedoms were significantly constricted because they had little to no say in family planning, he initiated conversations around birth control and contraceptives. While his ideas angered the orthodox, his life's work sowed the seeds of equality and equal opportunity for women in society. The auditorium where we have gathered in today is named after his illustrious daughter-in-law, Iravati Karve, one of the few Indian women in her time to receive a higher education and to study overseas. Her research work put many a dent in racial supremacy theories of her time. After returning to India, she worked for the betterment of the lives of the downtrodden. But what to speak now of the journey of constitutional values? Dr. Babasaheb Bhimrao Ambedkar, the principal draftsman of our constitution, bore a deep influence of these reformist and transformative ideals. He incorporated the values of liberty, equality, and fraternity directly into the Constitution. It is said that fraternity was not part of the original draft which was prepared by the drafting committee. Dr. Ambedkar pulled out a small chit in the course of the debates in the Constituent Assembly and said fraternity must be included as part of the fundamental values in the preamble. And so it came into the preamble. So he created, and his vision was to create what he called an ideal society that should be mobile and full of channels for conveying change. In his writings, including The Annihilation of Caste, Dr. Ambedkar addressed the cause of ending social discrimination. The Mahat Satyagraha and Babasaheb's report to the Southborough Committee spelled out a vision of an emerging post-colonial India which would be founded on the ideals of social and economic transformation. When our constitution was formally adopted on the 26th of January 1950, it embodied collective, often conflicting aspirations. And the beauty of our constitution is that it's a constitution which speaks in different voices, to different groups, to different ages. The Constitution as a document would not only have to serve as a bulwark against excesses of the state power, but also the deprivation of rights that arise through patriarchy, caste, and class hegemony. Our framers, comprising of founding parents, fathers, and let's not forget the 15 mothers, drawn from all castes and religions, understood this very well. It is for these reasons that our Constitution has carried horizontal rights guarantees, Articles 15 and 16, into the Constitution since its inception. Born of debates in the Constituent Assembly and inspired by federal structures abroad, most notably the United States division of powers and Britain's parliamentary model, while firmly rooted in India's own egalitarian and social justice ideals, the Constitution represented a delicate balance between universal principles of liberty, equality, and fraternity, and the preservation of national identity. At the birth of the Constitution, in the aftermath of partition, there was a fear. Will India survive as a nation? And you find that element of fear in the centralizing tendencies of the Constitution, which gave us a more powerful center as compared to the states. But that imbalance between the center and the states has been diluted by judicial interpretation. As years went by and India became a robust, strong, and independent nation, a need was felt to ensure the identities of the states. And that has been the process of judicial interpretation, to which I will come. When the Constituent Assembly of India met at the time of independence, its main task was to build a new social order based on the rule of law. The framers incorporated the basic components of the rule of law into the Constitution. A distinguished scholar, Granville Austin, captured the vision of our Constitution when he said, "The Constitution by its very existence was a social revolutionary statement. It was to be a modernizing force. Social revolution and democracy were to be the strands of the seamless web, most closely related. Democracy, representative government, personal liberty, equality before the law were revolutionary for the society. Social economic equitableness, as expressed in the directive principle of state policy, was equally revolutionary. So were the Constitution's articles allowing abolishing zamindari and altering property relations, and those allowing for compensatory discrimination in education and employment for disadvantaged citizens." The vision of the Constitution was so significant. Many Western powers were grappling with whether women should be given a right to vote, whether those who are not property should have a right to vote. For our Constitution, there was no question of discussion on this. Our Constitution gave universal adult suffrage and franchise. It did not deprive anyone of the right to vote either based on gender or education, postulating a fundamental principle that even someone who lacks education or literacy in those days prior to 1950 was equally capable of deciding on self-governance and Swarajya. The concept of justice lies at the heart of ethics as well as legal and political philosophy, guiding our appraisal of individual conduct, legislation, and public policy. In classical thought, justice ranked among the 4 cardinal virtues, sometimes elevated as the highest of the quartet, while in contemporary theory, John Rawls, the famous jurist, declared it the first virtue of social institutions, insisting that only a framework structured by justice can secure fair terms of cooperation amongst free and equal citizens. Justice in this sense has long been seen as a foundational virtue by classical thinkers and modern theorists alike. Yet from my experiences as a judge of 3 constitutional courts, the living reality of justice has always depended less on lofty definitions than on the ways in which communities interpret, implement, and contest their own rules. Baba Saheb Dr. Ambedkar said this in his last address to the Constituent Assembly on 26 November 1949 that however good a constitution may be, it may turn out to be bad if the people who interpret and wield the constitution are bad. However bad a constitution may be, it may turn out to be good if the people who wield the constitution in their hands are good people. So it is not enough, therefore, to have the right to life or personal liberty if judges are reluctant to grant bail, where the fundamental principle or the presumption of innocence gives way to the presumption of guilt. So how the Constitution works out in practice depends on who interprets the Constitution. And citizens have a valuable right because they are part of this dialogue on what we expect the Constitution to be. The preamble commits the nation to securing justice, social, economic, and political, which in practice has meant not only enshrining fundamental rights in Part 3, but also empowering courts to oversee their realization. Articles 14 through 17 enshrine equality and forbid discrimination. Articles 14 through 17, together with Article 39A, which mandates the provision of free legal aid so that poverty or disadvantage cannot bar access to the courts, form the fulcrum of the project. Over time, the judiciary's progressive interpretations, from enforcing procedural fairness in Maneka Gandhi's case to expanding the right to life and dignity under Article 21, have translated the promises of the preamble into lived capabilities for millions. Distributive justice, understood as the fair allocation of resources, finds its constitutional home in Articles 38 and 39, which guide the state towards reducing inequality and securing citizens' well-being. In practice, this has meant policies ranging from land reform to affirmative action, each debated and contested in public forums and courts. The tripartite conception, social, economic, and political justice, reflects the insight that freedom must be accompanied by real opportunity. Legal equality alone is insufficient if basic education, health, or economic security remain beyond reach. Social justice has driven movements to dismantle caste discrimination, to extend education and health care, and to protect marginalized communities. Economic justice has inspired policies for land distribution, workers' rights, and welfare support, always subject to democratic deliberation and judicial review. Political justice has meant the extension of universal suffrage, the empowerment of local self-government through the 73rd and 74th Amendments, and the maintenance of free and fair elections by an independent election commission. Each of these advances illustrates that justice is not static, but a dynamic process of public reasoning, contestation, and reform. In other words, justice emerges not simply from legal text, but from the collective exercise of reason, empathy, and moral imagination. Our task then is to sustain fora, the courts, legislatures, civil society spaces, where the meaning of justice can continually be tested and enriched, ensuring that the constitutional boat built on the ideals of the freedom struggle remains responsive to the changing needs and aspirations of all citizens. In the 75 years since 1950, the central commitment to justice under India's constitution has repeatedly been reaffirmed and sharpened through the decisions of its courts. Obviously, there have been aberrations. The cause of justice is cyclical, and there are times when justice has been under threat, such as during the emergency. Not only that, courts have played a key role in furthering justice through unlocking hidden dimensions within the explicit rights guaranteed by the Constitution. Let us look at some of the landmark verdicts in the last 50 years. A succession of landmark cases in the 1960s and 1970s, from Keshwanand Bharati's bedrock assertion of the basic structure, through insistence on rights as inviolable, checks on arbitrary power as seen in Minerva Mills, established the framework on which further developments have taken place. The era also gave us verdicts that arose out of a siloed and text-bound approach, seen through decisions like A.K. Gopalan. But the most abiding aspect of our constitutional law is that no verdict is set in stone for the coming generations. It is always open to us to reinvent our rights framework as society reinvents herself. One such case was the landmark Puttaswamy, where I joined a unanimous bench to recognize privacy as an intrinsic facet of dignity and liberty under Articles 14, 19, and 21. In that sense, Puttaswamy inaugurated a new constitutional paradigm. We realized that it was necessary to articulate a vision of privacy as a wellspring of personal agency and democratic participation. This would enable individual rights to flourish and protect themselves from many invasions that the digital age causes in the autonomy, dignity, and self-determination of individuals. We also realize that a complete realization of the privacy and autonomy dimensions of Article 21 was often inhibited by our own laws. In the dismantling of archaic and oppressive provisions like Section 377 in Navte Johar, which decriminalized homosexuality between consenting adults, and Section 497 in Joseph Shine, the Supreme Court has advanced justice by preserving individual dignity and protecting substantive liberties in the face of new social and political challenges. Over this span, our constitutional jurisprudence has carried new path through the forging of safeguards to new frontiers of personal autonomy and equality. In Joseph Shine, we said that a woman cannot be regarded merely as a property of her husband, nor can she, by merely entering upon marriage, be construed to forsake her individual agency and autonomy. Section 497 made adultery a crime, but penalized only the husband in an adulterous relationship, the man in the adulterous relationship, not the woman, on the assumption that the seducer is only the man, never the woman. We said this is not an assumption which the law can make in a post-colonial India governed by the Constitution. More importantly, the offense would be condoned if the husband of the woman consented to the relationship. So we struck down Section 497, saying that it is not consistent with the dignity of women in a truly independent and socially transformed nation. The legal concept of indirect discrimination holds significant promise in ensuring greater participation and empowering of women and minorities. Indirect discrimination occurs as a result of laws that are facially neutral, which have the effect of having a disadvantageous impact. While Article 14 did not explicitly recognize indirect discrimination, the full realization of the vision it articulates would be incomplete. For almost 6 decades, this was lacking. In 2021, the Supreme Court was petitioned by women army officers seeking to be allowed to be appointed as permanent commissioned officers in the armed forces, challenging the tenure limit of 10 to 14 years and the unfair criteria of the medical boards. In my opinion, it caused immense disservice to the contributions of women in the armed forces to deny them permanent commission, since this was based on gender stereotypes. Women in society are often inhibited, not by intentionally discriminatory norms, but by institutions making decisions on their behalf without taking into account their voices. Thus, we held that women short service commissioned officers would be entitled to permanent commission at par with male officers. The government had argued that the Russian warships, which India has, did not have a place for toilets for women on high seas. And we said, too bad, you have to create those toilets for our women commanders and our women sailors. The answer cannot be to exclude them. So you now have women in guarding our borders, you have women who are fighter pilots, donning the Air Force uniform on the Rafale jets. You have women on the high seas commanding our warships. That's the sign of changing India. That's the sign of a constitution which has been resilient to new interpretations as the aspirations of our society have changed. In Sukanya Shanta versus the Union of India, which we delivered a few months before I retired, we were confronted with the lingering ills of caste and caste-based segregation in our prisons. Owing to our prison manuals, remnants of colonial times, the caste, class, and unproven criminal antecedents of inmates formed the basis of manual wage jobs which were assigned to them. The prison manual said who could cook, who would sweep, who would clean the toilets, who would cut hair. There were several painful instances where members of communities historically assigned manual scavenging work continued to be forced into that practice in the prisons, which was outlawed by the judgment in Sukanya Shanta. But the constitutional promise is unfinished so long as a single person is relegated to indignity on the grounds of their caste. I'm stating the obvious here when I say that caste-based differentia in these prison rules bore no nexus with the objective of the manuals, which was effective and orderly management of the prisons. What was so obvious to us as lawyers and judges remained the reality of the men and women languishing in prisons from 1950 or earlier till 2024, compounding their suffering each day. Thus, we must examine critically and keep on interrogating our laws for every hidden injustice that is revealed. If we fail to do so, we do a disservice not only to the citizenry, but to all those who fought society and won over these rights, often at great personal cost. And therefore, I began by the history of social and political emancipation which Maharashtra has led from the forefront. In my last court term as Chief Justice, I was confronted with a case where we realized that our decision would have a direct bearing on how India navigates one of the foremost challenges of the 21st century, climate change and combating its impacts. As courts, we cannot afford to refuse to take judicial notice of the specter of climate uncertainty that haunts our society. It presents an imminent threat to the right to life under Article 21. In M.K. Rangjit Singh's case, we dealt with the preservation of probably the last big bird on the planet, namely the great Indian bustard, which was threatened by the laying of transmission lines in the desert in Rajasthan. The question was, do we not need solar power, which we do, as a replacement for fossil fuels? But yet we have to preserve these last dying species that will preserve the biodiversity of the planet. I mean, we've tried to make that balance in our judgment. And we took note of the various international obligations that our state must take into account, in addition to presenting a set of pragmatic solutions to tackle the attendant crises. Over these 75 years, constitutional litigation has restored and expanded the promises of justice. First by securing constitutional supremacy and procedural checks, then by widening substantive rights to livelihood, privacy, and autonomy, and by enshrining equality before the law, but in the substance of economic and social opportunity. Justice is thus not a static inheritance, but a living commitment, continually renewed in the courts and carried forward into each new challenge. On my last day as the Chief Justice, we handed down the verdict in the Property Owners Association case. As our Constitution, as you all must know, safeguards the right to property as a legal right under Article 300A. It's not a fundamental right after the 44th Amendment. This right is essential to ensuring the economic dignity and livelihood of individuals. Under Article 39B, there is a positive obligation that the state must secure that the material resources of the community be distributed in a manner which subserves the common good. In some ways, we were called upon to examine the extent to which private property can be reconceptualized as a material resource of the community to enable state intervention for socio-economic welfare. In my view, economic rights and social justice are not opposed but mutually reinforcing. Our constitution is not a socialist constitution, though socialism is written into the preamble. It came in by the 42nd Amendment. In the drafting process, Dr. Babasaheb Ambedkar was clear that no one economic philosophy could be forced into our constitution. Thus, it was necessary for us to balance private property with the objective of Article 39B. In a judgment which was delivered by Justice Krishna Iyer, in the 1970s, it was said that the individual is a member of the community, and therefore every property which belongs to the individual is a material resource of the community. Come 50 years later, and we asked ourselves one question. If an investor who wants to set up a semiconductor plant in Assam or Gujarat or Maharashtra is told that every part of your property is a material resource of our community, all that he would say is, thank you, but I'm not going to come and invest in India. So it was time to bring about a correction, a course correction in the Constitution itself. While not all private resources automatically become communal resources, where private holdings serve broader social objectives, such as slum redevelopment or affordable housing, they may justifiably be treated as material resources. In holding thus, we also drew exception to the views advanced by Justice Krishna Iyer, which were influenced by a particular school of economic thought prevalent at the time. India's economic trajectory reveals that the electorate has routinely rejected economic dogmas, and to ensure economic democracy and 21st century economic aspirations of sustainable growth and equitable development. We are a young nation. We are increasingly reaping what is called the demographic dividend. Interestingly, recent figures, in fact, there's an article in The Economist today, recent figures reveal that the rate of fertility is now reducing across the world, including in India. The rate of fertility in India is now down to 1.9, 2.1 in the rural areas, 1.5 in the urban areas. Now, the impact of this will not be felt immediately, may not be for the next 75 years, but it's going to be felt in countries like China and much of Western Europe. Now, how do we reap the demographic dividend today as a society? And that we can reap by reinterpreting the Constitution to liberate entrepreneurship, liberate innovation, to not utilize our laws as a restraining influence on the ability of our younger generation to innovate, to bring to the fore new ideas, to set up startups, whether it's in the field of medicine or other areas of technology, as a part of the process of reimagining a new India. But while we have to necessarily grow and innovate as a nation, we must understand that there are yet today pockets of underdevelopment. And my nearly 25 years as a judge reminded me every day that it's in the work which each one of us does where the ability lies to soften the rough ends of justice. Like in the case of a young Dalit student who was admitted to IIT Dhanbad, who couldn't pay the fee because though his sister gave him her credit card for uploading the fee, by the time that process was complete, the last moment was over. Or another student, a child of a daily wage laborer, admitted to IIT Bombay, was not able to gain admission for the simple reason that he had no money to pay the fee within the time which was stipulated. Many of these students went first to Chennai because the IIT JEE was held in Chennai, went to the High Court. They were told that Chennai, the Madras High Court has no jurisdiction, went to the Delhi High Court. Delhi said, we don't have jurisdictions, until they landed in the Supreme Court. Now, we all live in the age of artificial intelligence, and that's the last thought on which I will leave you. Artificial intelligence is bringing about a revolution in contemporary societies. But there are some things which cannot be left to artificial intelligence. Doing justice in individual cases of injustice is something which the human mind, with all its imperfections, can perform. But there are dangers on the horizon as well. And as I conclude, I must highlight these dangers for you as well. Freedom of speech is one of the cardinal fundamental values which is protected by our Constitution. Freedom of speech is prized by all democracies across the world. But you have someone who was shot dead in the University of Utah yesterday for giving expression to a particular viewpoint. Whether you like that viewpoint or not is a separate issue altogether, a conservative viewpoint. Now, what social media and the advent of technology has done is that technology has made us increasingly intolerant of ideas which we do not accept. Technology has increasingly, and particularly social media, has made us intolerant of people who don't think like us. The algorithms on which artificial intelligence is based gives you more of what you want to hear and what you want to see. So some of you have ordered a pizza online. Your smartphone will be flooded the next day with alternative options for purchasing pizza. If you want to travel from destination A to destination B, your smartphone will give you more options for traveling by less expensive options on that very route. Social media, therefore, generates a view of social reality in silos. You get to hear what you want to hear. You see what you want to see. But the true basis of freedom, the freedom which was based on the social and political reformers which Maharashtra gave us, was exactly in hearing ideas which were not popular at that time. In understanding that there were perspectives which were not part of the mainstream of that time in colonial India. But it was those people who stood apart from what was then the mainstream of society who gave us an aspiration for a better future. So social media is equally capable of generating hate, of spewing venom. Social media, as I read recently, may even lead you to believe that violence itself is virtual and a killing itself is virtual, not understanding that violence and the consequence of violence is not virtual. It may be portrayed virtually, but all forms of violence are real, whether it's in the context of domestic violence or communal violence, or violence across nations, as we are seeing in the conflict between Russia and Ukraine today. So then, as I conclude, let me tell you that an important takeaway from my own judicial career is just precisely this, that constitutional interpretation requires us to move beyond a formalistic approach towards a more substantive evaluation. In examining the transformative character of the Indian Constitution, we must not ask merely what the text says, but what it enables, what freedoms our Constitution expands, what capabilities it enhances, and what opportunities it creates for human flourishing. We must ask ourselves simple questions. What do you mean by merit? Is merit only defined by the scores which you get in competitive exams? Or is merit to be defined in a more inclusive sense in bringing into the mainstream all segments of the community? Because it is when all segments of our society are brought within the mainstream that we can truly speak of a stable and meritocratic country. Around us, if you just look around us, whether it's in Nepal or it's in Bangladesh, violent movements have taken place, spurred in large part by Gen Z. What is it that has given India a sense of stability? For some of you, the source of stability of India may lie in the family values which we have. For some of you, the stability of India may lie in democracy, the ability of each one of us to participate in governance. For some of you, the stability may lies in the profound recognition of the importance of faith in giving us a sense of calm across religions. For some of you, the stability of the nation may lie in the Constitution. I think on an occasion like this, we must understand what a great stabilizing force the Constitution has been in our country. And the stabilizing force of the Constitution lies precisely in this, that the Constitution has been broad enough in its vision to understand as a document, as a living document, that what she meant in 1950 has progressively changed to keep pace with what the Constitution must mean today to meet the aspirations of society. So we are all part of this constitutional project. Our lives give meaning to the Constitution. Our engagement with each other gives color to the Constitution and gives it this great stabilizing force where we listen to each other, talk to each other, but remember that we are part of one stable nation state. Therefore, we must respect text, we must honor context, and we must live with our Constitution. Thank you very much for this opportunity. Namaskar.
Thank you so much, sir, for that edifying discourse, which enumerated not only on myriad of topics, but also established Maharashtra's position as a bastion with regard to the development of the Indian Constitution, the constitutional values, and morality. As we draw this inaugural session towards its conclusion, I invite our beloved Professor Dr. Sonia Nagrale ma'am to deliver the formal vote of thanks.
Thank you, Abir. Very good afternoon to all. The Constitution represents the charter of power granted by liberty and not the charter of liberty granted by power. Our chief guest, Honorable Justice Dr. D.Y. Chandrachud sir, quoted eminent jurist Nani Palkhiwala in his speech on why the Constitution matters, which in its true sense resonates with today's seminar. Undoubtedly, the most appropriate, erudite, and distinguished person to inaugurate this seminar, whose very presence embodies the spirit of our Constitution and whose profound judgments give it living expression. It stands recognized that Honorable Sir, by virtue of his immense experience, unwavering dedication to judicial service, and persistent commitment to democratic values and social justice, has exemplified the principles of constitutional morality. Sir, I extend my deepest gratitude to you, that is, Honorable Justice D.Y. Chandrachud sir, former Chief Justice of India, for gracing today's seminar with his reflections and his insights. I also wholeheartedly thank Professor Dr. Suresh Gosavi, sir, Honorable Vice Chancellor of Savitribai Phule Pune University, who, as the head of the university, has provided his invaluable guidance, incessant support, and encouragement. Under his visionary leadership, this seminar has found its true direction and achieved meaningful success. I sincerely also thank Professor Dr. Parag Karkar, sir, Honorable Pro Vice Chancellor, for his constant encouragement and unstinted support, which has always been a source of strength to us. Ravindra Shingnapurkar, sir, Chancellor's nominee to the Management Council and convener of this seminar. Sir, your convening the seminar signifies the university's strong administrative and managerial backing for academic events. We remain grateful to you, sir, for your valuable support, which have greatly enriched this occasion. On behalf of the university, we are profoundly grateful to respected Professor A. Lakshminath, sir, an illustrious academician, a pioneer in the field of jurisprudence, and a genius of constitutional thought, for accepting our invitation and gracing the seminar with his esteemed presence. We are equally indebted to Professor Dr. Jyoti Bhakre, ma'am, the officiating registrar. Your robust support reflects the vital academic, administrative guidance, and coordination that you, being a part of the department, continually receives from the university. Your support ensures that our initiatives are not only academically enriching, but also effectively organized and implemented. I also express my sincere thanks to Advocate Dr. Uday Varunjikar, sir, member of the coordinating committee, for his valuable assistance and thoughtful coordination with our chief guest. A very special note of thanks to Professor Dr. Vijay Khare, sir, Dean, Faculty of Humanities, whose steadfast guidance and tireless efforts have been the driving force in turning the seminar into a meaningful reality. I also thank Professor Dr. Naresh Wagmare, sir, Head, Department of Law, for his support and encouragement throughout. My special thanks goes to Head, Department of Education and Extension, for providing the essential infrastructure, seamless arrangements, and support that have ensured the smooth organization and success of the seminar. My sincere thanks to the coordinating committee members, Advocate Vidyadhar Gulkarni, sir, Advocate Ishani Joshi, ma'am, Krishna Pandalkar, sir, Rahul Pakhare, sir, for your efforts, dedicated execution, which has been the backbone of this seminar. I extend my thanks to all the teaching, non-teaching staff, research scholars, students of the Department of Law. Their behind-the-scene contribution, attention to details, and sense of responsibility has ensured the smooth conduct of this inaugural session. Our warm appreciation also goes to all the respected judges who are present here, lawyers, principals, all the respected members of the Management Council, Senate members, Academic Council members, faculty members, all the respected speakers, distinguished guests, research scholars, the media people, students, participants, the chairperson, moderators, and the rapporteurs of all technical sessions who have gathered here to make this seminar meaningful. I'm confident that your active participation, encouragement, and support are what make such academic pursuit truly vibrant. Finally, I must acknowledge the untiring effort of the Estate Office, Finance Department, Teaching, Non-Teaching Administration, PRO Office, EMMRC, IT Cell, the housekeeping staff, the Security Office, and all the volunteers who have worked for the seminar. Their dedication, enthusiasm, and commitment to excellence have ensured the flawless conduct of the inaugural session. With these words, I once again express my heartfelt gratitude to one and all for your gracious presence. Thank you very much.
May I now request the Senate members and the members of the Management Council to come on the stage for a picture with the Honorable Chief Guest and the dignitaries on the dais. Additionally, after this, there would be a 15 minutes break and the registration counter will be open for the registration. Kindly ensure that you have registered with the relevant registration committee, and then we will commence our session for Professor A. Lakshminath sir. Thank you.